Recording acts and constructive notice for the national portion of the real estate exam focus on how public records protect property owners and notify the world of their interests. This is a critical area where the exam tries to trip you up with timelines and the sequence of events regarding who legally owns a property when multiple deeds are involved. When we talk about recording, we are talking about the act of placing a document in public records at the county level. The exam wants you to understand that recording is not a legal requirement for a deed to be valid between the grantor and the grantee. A deed is considered valid the moment it is delivered and accepted. However, recording is absolutely necessary to protect the grantee against claims from third parties. This leads us to the concept of constructive notice. Constructive notice is a legal presumption that everyone has knowledge of a fact because it is available in the public record. If a document is recorded, the law assumes every person in the world knows about it, whether they actually check the records or not. This contrasts with actual notice, where you have direct knowledge of a fact, such as someone physically telling you they own the property, or you seeing a tenant living in the house. On the exam, you will encounter scenarios involving multiple conveyances. For instance, if seller Sam sells a house to buyer Bob and then sells the same house to buyer Charlie, you must determine who owns the property based on the recording statute. The first type is the race statute. In a race jurisdiction, the rule is simple, where the person who records their deed first wins, regardless of whether they knew about the other buyer. It is literally a race to the courthouse. If Charlie records before Bob, then Charlie owns the property, even if Bob bought it first. The second type is the notice statute. Here, a subsequent purchaser, like Charlie, wins if they are a bona fide purchaser who took the property without notice of the prior sale to Bob. If Bob did not record and Charlie had no idea Bob existed, then Charlie wins. Under a notice statute, Charlie does not even have to record first to win because he just has to be the most recent buyer without notice. However, if Bob had recorded, that would have provided constructive notice, and Charlie would lose because he would be deemed to have notice. The third type is the race notice statute, which is a hybrid used in many states. To win in these jurisdictions, Charlie must both be a bona fide purchaser without notice of Bob's claim, and he must record his deed before Bob records his. If Charlie finds out about Bob before he buys, he loses. If Charlie buys without knowing but Bob records before Charlie can get to the courthouse, Charlie also loses. A common exam trap involves wild deeds. A wild deed is a recorded deed that is outside the chain of title because a previous link in the chain was never recorded. For example, if Alpha sells to Bravo and Bravo sells to Charlie, but Bravo never records the deed from Alpha, then the deed from Bravo to Charlie is considered wild. Even if Charlie records it, does not provide constructive notice to future buyers because a searcher looking at the records of Alpha would never see the transfer to Bravo or Charlie. The exam will ask if a wild deed provides notice, and the answer is always no. To remember these types, think of the phrase race for the record, notice for the knowledge. Another trick wording to watch for is the difference between a valid deed and a recorded deed. Do not let the exam fool you into thinking an unrecorded deed is void, because it is perfectly fine between the original parties, just dangerous against third parties. Finally, remember that a bona fide purchaser must pay value. Someone who receives a property as a gift is often not protected by these acts against prior unrecorded interests.